Hi, Nick Dogle, North State Law. We safeguard your professional license so you can get back to business. Today, we're going to talk about, does a prior Division of Child Development Early Education administrative action impact a new complaint against a daycare facility? So, very long question, and the answer is not going to be short, but it could be a lot longer. So, what I want you to do is, there are a number of videos that kind of explain like what an administrative action is, what a written reprimand is compared to a written warning. So make sure that you check out those videos because it'll offer a lot more answers than what I'm going to get into, because I'm not going to do a rabbit hole out of every single little thing because I've already done videos on those. And those are going to go into more details about those specific questions. So the video that has information about what an administrative action is, that's actually the penalties for Division of Child Development Early Education, that video. So make sure you check that video out, be a further explanation into the administrative action. So administrative action is basically the penalties that's implemented by the Division of Child Development Early Education. So you get a notice of administrative action, and I'm going to use an example of you get one for lack of supervision. So lack of supervision is going to be considered child maltreatment in North Carolina. And say you get a notice of administrative action for a revocation. They want to revoke your license. You need to make sure that you get your appeal in. The appeal is done with a petition for contested hearing. Got a couple videos on that sort of process as well, so make sure you check those out. And then you do appeal that. Let's just say you work something out, and let's just say for argument's sake, you get it worked out to a written reprimand. So your administrative action / penalty is a written reprimand, and that is for one allegation of a lack of supervision. All right, so let's say that happens in 2022. Fast forward to 2025, you get a new allegation, but this one is different. It's regarding a staff-to-child ratio, that your facility was out of compliance with the required number of staff members per children that are being watched at the time, okay? So is the old administrative action / penalty of a written reprimand for something completely different, like lack of supervision, is that going to impact the new complaint for something completely different, which is being out of staff-to-child ratio? So the short answer to the question is, it's been told to me by staff with the AG's office and DCDEE that it's not supposed to. Their policy is, if this is for something completely different, you haven't been in trouble about it before, then they're going to treat this as a blank slate, essentially. Realistically speaking, is it always that way? In my experience with my clients, I would say not always. I would say sometimes. I would say the overwhelming majority of time is, yeah, they have a tendency to stick with adhering to that internal policy. But I also have seen the DCDE kind of veer from that internal policy and bring up stuff in the past that wasn't relevant to the future, and say, well, you got this in the past and you got a little bit of leeway with us there, even though it was completely unrelated, and kind of use that in subsequent allegations for something completely different, and that the facility's never been in trouble before. So that's why it's important to know a lot of different things. What you're being alleged to have done. What code am I supposedly violating? What statute am I supposedly violating? What is the real allegation here? And sometimes that's not readily apparent. That's why it's important not to really rush into anything. It's also important not to miss any deadlines, like I mentioned before. And you always have to understand, like, look, I have a right to appeal whatever administrative action that they put out there. And if they come out with something that I feel is reasonable at the time, maybe you do want to take it, but also maybe you want to explore all options, and you appeal that to the Office of Administrative Hearings by filing your petition for contested case. And you can still work something out with them. You can say, you know what, I filed my petition, but I've gotten more information from you. I'm confident now that you're right, I'm wrong. I apologize. This is what we've done. We've corrected everything. I'll work on with you on a corrective action plan. Most of the time, that stuff's done before a notice of administrative action is considered by the division. But let's just, for argument's sake, that you haven't had much communication with them. You work stuff out like after the fact, after you get more information. The point I'm making is you don't want to rush into a decision regarding the final outcome of your case with DCDE because it can impact you 3, 4, 5, 6, 7 years down the road. Because I have seen them bring that stuff back up. And yes, sometimes they don't, but will say I have seen them do that multiple times before. Where they'll reach back, 5, 6. I've seen them even reach back like 8 years and say, like 8 years you got in trouble for this. It's like, whoa, that was a long time ago, and also that was for something completely different. I've also seen them go back, maybe 10 years, but it was for the exact same thing, and say, look, 10 years ago you got X, Y, and Z. Now those are extreme examples. Most of the time they won't go back that far. But what I'm saying is, based on my experience, I have seen them do it a little bit. So you want to be really careful and not rush into any decisions, not have that administrative action become final until you have a lot of information. You've kind of seen the information that they have, the evidence that they have. And then if you're satisfied that, what, you got me, I did something wrong, I'm sorry, and then you've made corrections there to make sure that your facility is not going to do it again, your employees are not going to do it again. And it might be a situation where you got to make a tough call and get rid of an employee or two because they were just doing something that was out of line with what you've talked with everybody about. And that happens too, and it is what it is. But don't rush into decisions, because what you finalize today may impact you tomorrow, 5 years, 6 years down the road. So you want to be really, really careful. So I hope that information was helpful. Go check out the other videos on the YouTube channel like I talked about. You'll find a lot more useful information in there. You get some good nuggets out of it. Also, I got a lot of blogs on the website, northstatelawfirm.com. So check that one out as well. And if you still can't find what you're looking for in either one of those spots, feel free to give my office a call or a text, 919-521-8810, and you get a free 15-minute discovery call with a member of my staff. Thank you so much for taking care of North Carolina. I hope everybody has a fantastic day. Bye-bye.